Hearing the appeal AWH Fund Limited against ZCM Asset Holding Company Limited.
Mr. Sims, we're very sorry to hear that you're not in the best of health today. If you require a break, just say so and we'll adjourn immediately.
Thank you, my lord. I hope that I'll be These are lordships. I appear along with Mrs. Sophia Roll-Kapasusiglu for the appellant. I also have, sitting in the back, Mrs. Lexa Hilliard, who was going to be my stand-in this morning if I couldn't make it. So I thank her for coming along on short notice. My learned friend, Miss Carolyn Walton, along with Miss Trevette Pyfram, is appearing for the respondent. And I know that she has the liquidator, Mr. Alan Bates, is here in court as well today. Lords, this is an appeal arising from the Court of Appeal of the Bahamas. There are a number of grounds of appeal, but essentially it boils down to one question, really. And that question is whether a claim pursuant to Section 160 of the Bahamian IBC Act can be served out of the jurisdiction on a foreign defendant. Lords, it may be worthwhile perhaps having a look at quickly at the relevant sections insofar if you haven't seen them. They are in Bundle 1 at tab 7 or page 703 in the electronic bundle. That's Bundle 1 of the authorities.
Sorry, what page did you say?
Sorry, it should be at page, the Act is at 693, but at page 703 you'll find Section 160. That section reads, any conveyance, mortgage, delivery of goods, payments, execution, or other act relating to property, as would, if made or done by or against any individual trader, be deemed in the event of his bankruptcy to have been made or done by way of undue or fraudulent preference of the creditors of such trader, shall, if made or done by or against any company, be deemed in the event of such company being wound up under this act to have been made or done by way of undue or fraudulent preference of such company, and is valid accordingly. And then it goes on to change the time periods to those of a filing of a petition or a resolution for winding up in terms of the calculation of any time. And then it goes on to say, shall be deemed to correspond with the act of bankruptcy in the case of an individual trader, and any conveyance or assignment made by any company formed under this act, or all or any part of the estate and effects to the trustee for the benefit of all or any part of its creditors is void. So essentially this ties in the Bankruptcy Act, which we'll go to momentarily. And our Bankruptcy Act is from 1870. It has not been altered in any way, I think, from its original or amended since 1870. And it is our primary submission that the jurisdiction or the extraterritorial jurisdiction must be judged from the extraterritorial jurisdiction of the Bankruptcy Act. I say that for two reasons, which we'll come to, but one is the fact that for this section to apply, you must be a person to whom the Bankruptcy Act would have applied. And as such, that would include the type of person that could be served under the Bankruptcy Act. There simply is no method whatsoever under the bankruptcy rules or the Act to serve outside of the jurisdiction. But before going to the Bankruptcy Act, if I could take you across the page to two other provisions which we'll be discussing, and we may as well look at them now, is 154. In the winding up of an insolvent company, the same rules shall prevail and be observed with regard to the respective rights of a secured and unsecured creditor, and to debts provable, and to the valuations of annuities and future and contingent liabilities as are enforced for the time being under the law of bankruptcy, with respect to the estates of persons adjudged bankrupt and all persons who, in any case, would be entitled to prove for and receive dividends out of the assets of the company may come in under the winding up and make such claims against the company as they are entitled by virtue of this section. So that is adopting 154 in respect of the parameters set out therein, is adopting the bankruptcy rules. We say that we are a contingent creditor, and I'll come to that point a little bit later when I develop it, but we also point out just at 153, you'll see that in the event of a company being wound up under this act, all debts payable on a contingency and all claims against the company, present or future, certain or contingent, ascertained or sounding only in damages, shall be admissible as proof against the company. A just estimate being made as far as possible of the value of all such debts or claims as may be subject to any contingency or sound only in damages, or some other reason do not bear a certain value. So in other words, a contingent claim can be proved in a bankruptcy. We believe that we would be contingent creditors and we would fall under 154, and that would also take us to the rules of bankruptcy. Now,
When you redeemed the shares, were you paid in full?
we were paid in full. All of the shares, the evidence is, which is contained in the Damien Neville affidavit and the Thomas Prudy affidavit, is that all of the shares which were held by this company for the benefit of American Express were redeemed. And the Court of Appeal found so at paragraphs 15 and 16 of their ruling. So at that point, the shareholder had, or I should say, the appellant in its capacity as agent for American Express had no more interest in the company.
Would you be a deferred creditor?
I don't think we're a deferred creditor. I think really we are contingent in the sense that when we've been paid, we're no longer a creditor, but if the fraudulent preference is proved, the claim against us obviously makes that transfer to us or the payment void. So on that basis, we're contingent. And so,
And your claim is then under the request for redemption, i.e. in your capacity as a member? Yep.
yes, we fall back into the unsecured creditors. We fall pari passu. So, my lords, you will have seen our statement of case, which goes through all of the grounds of appeal in detail. I don't plan today to go cover all of those grounds because we have a short amount of time today. I think we're 2 hours before I let my learned friend get on her feet.
You can take it we have read the
Yes.
written cases in full.
And I figured you would be familiar with many of these quick cases. But the heart of this appeal, there are basically three main topics which I wish to cover. One is, does the IBC Act, and particularly Section 160, have extraterritorial effect? If the answer to that is yes, can a claim under Section 160 be served out of the jurisdiction? Can it be commenced by an interlocutory summons pursuant to the rules of the Supreme Court, Order 11, Rule 8.4? If the answer to that is yes, were the requirements in this case met for such service? Now, just in terms of a roadmap to go through that, my lords, I will take you through those points. But firstly, I wish to take you through the facts of this case which are relevant. Then I'll address you on the three topics that I've just outlined. And then lastly, I will talk on speak to one or two grounds in which I felt would be helpful to address the court, although they're not part of the main grounds of the appeal. So the background, my lord, to this case is obviously that this was a IBC, International Business Company, incorporated as a mutual fund in 1997, and it was incorporated under the IBC Act of 1989. That act has since been replaced by the Act of 2000. There has been a subsequent amendment really to that act in terms of winding up procedure, but all parties are in agreement that the rules that apply are the rules of the 2000 Act as they were and as we have them before you. So the appellant held these shares as agent or bearer trustee for American Express Offshore Alternative Investment Fund. And I don't plan on taking you to the actual evidence other than perhaps to one or two illustrations, but I will refer you to where you can find that.
Sorry, when you say agent or bear trustee, I thought it was clear that it was bear trustee.
Well,
Right.
yes, I mean, in terms of, often those words are interchangeable depending on the scope of the agency, but all that we're doing was holding the shares. Really, the nominee, I suppose, is a better word, so bear trustee would probably. They held it under a custodian agreement, which is exhibited to the affidavit of Thomas Purty, and you'll see in there that they don't really have any discretion. They're in fact a sub-custodian, and they had to follow, the only way they could take any action was on the directions of American Express. And so they were, in a sense, a bear trustee. So you will find that stated at in the affidavit of Damien Neville, which is at tab 5 and also at, I think, page 43 in the record, the electronic record, and you'll see that at paragraphs 12 and 13. I don't plan on taking you to it, but I will take you to some examples of where that was acknowledged. You'll also find it in the affidavit of Thomas Pruty, and that is at tab 15 and at page 143 at paragraphs 16, 17, 23, and 24. So every single form, and we're going to look at a couple of them, but in every single form in this matter, whether it was a subscription, correspondence, a redemption's notice, all said the appellant's name, FBO, client account, American Express Offshore Alternative Investments Fund. So if I could ask you, please, to take up, which would be, I think, the original bundle one, the appeal documents bundle, which is really the evidence and the rulings, at page 253. Which is tab 14, sorry, 15? Tab 15. Is that right? Yeah.
Yes.
53. So you will see that this is a letter from the administrator of the fund, which was Fortis, to the directors. And you'll note item 3. They are seeking approval for the total amount of redemption payable to ZCM Asset Holdings client. You'll see how they address it. ZCM Asset Company, Bermuda Limited, client account FBO American Express Offshore Investments, based on the June 30th NAV. The redemption notes which come out, which if you just turn the page over, there's a series of them, but at 255, you will see the first one. And they, again, at the top, the registered holder, being the registered the holder of the shares, again recognizes that this is a agency relationship and that the shares are being held, just in the top right corner, the shares are being held on behalf, so that's at page 255 of the record. The shares are being held on behalf of American Express. There are all of the documents, and I won't take you to them all, but there's 5 or 10 of them, but every single correspondence between the appellant and the respondent addressed the shareholding in this capacity. The subscription agreements where they had the name shareholder, that's what was placed there. That's the name the documents were signed in. That's the consistent name. Now, the other point, which I think my lord picked up on, really was that all of the shares were redeemed. And I just, for a note, you can find that at paragraph 13 of the Damien Neville affidavit or paragraph 21 of the Thomas Pruty affidavit, and those are pages 45 and 147 in the record if you wish to see it. And also, as I said, in the Court of Appeal ruling, they make that finding at, I think it's paragraph 15 or 16. And so what happened was that on July 24th, following a redemption request by the respondent to pay out all of the shares on behalf of American Express, by the appellant, the respondent paid out the sum of $13,148,013.01. And these funds, which were then received by the appellant, were paid over within 2 days to American Express. And that was on July 26th in 2002. The evidence for that is in the Thomas Prudy affidavit. Then, on October 17th, 2002, there was a winding up petition was presented. The winding up order, however, was not made until 18th of May, 2004. On June 27th, 2008, the liquidator obtained leave pursuant to rules of the Supreme Court, Order 11, Rule 8.4, to serve the amended interlocutory summons out of the jurisdiction. That amended summons, my lords, is at tab in the appeal documents is at tab 7, and it is at pages 37 and 39. Now, I point out that one is that it gives, that's the amended summons filed July 1st. So not only does leave was granted to serve this summons out, but at paragraph 3, I ask you to note that not only are they seeking a declaration, the declaration is at paragraph 1 that it's a fraudulent preference, but at paragraph 3, they are seeking an order that the appellant pay the money to the company. And the reason I just want to put a marker there, and I'm going to come back to it, is under our Act, there is no power for the court to order the money to be paid back. When I come to what is the cause of action, I'm going to focus on this momentarily to say there is, under our statute, you can get a declaration, but the money is still held with the other person. Somehow you've got to get the money back. And we're going to see that it is probably an action for presumably money hadn't received. In the old days, in the old cases, they got into it by quasi-contract, but that's how they found their route through Order 11. So it is more than just the statute. There needs to be a pleaded case to get the funds back, which there isn't in this case. But I'm going to come to that, my lords. Just really putting a marker down there.
So the first stage is to have the payment effectively avoided on the basis that it's a fraudulent preference. And if that's done, then it follows that there's simply no basis on which the recipient of the payment can, well, in principle, I mean, subject to all sorts of defences, in principle, a claim lies against the recipient for money hadn't received, and equally, the recipient will rank as a creditor because the debt has no longer been is not discharged by any payment.
That is correct.
Is that right?
Yes, yes. And so, I mean, in the English legislation, obviously, later on they cured this, and the various sections the court can also give orders for the money to be paid at the same time that they declare that it's a fraudulent preference. In the old days, it was, well, now we've declared it a fraudulent preference. What's our claim to get the money back?
Yes,
right.
Two of us on this court, in fact, have been looking at this recently in the context of another case from Cayman, I think.
Well, then the Lord maybe will assist us in understanding it all.
Judgment is pending.
After dealing with this, my lords, I think anything arising from Brexit should be a walk in the park. So the point here, my lord, is this summons does get served. I think it gets issued in July. So this is almost 6 years after Amex has passed the money over. 6 years. And it gets served in September, so well past 6 years. Subsequently, the court gave leave for the appellant to enter into conditional appearance to challenge jurisdiction. And that's really what brings us where we are today. So the first point of law really on ground is really our ground one, which is that Section 160 simply does not have an extraterritorial effect. Now, before going there, my lords, I will say this, is I wasn't going to address you on the cases in terms of the principles of construction. One, because I think that counsel on both sides have agreed with those. relevant cases are and the principles. And secondly, I'm sure my lords will be well those cases. What I was going to therefore address you was sort of getting right into the grounds and looking at the specific grounds and the case law affecting those grounds. So the first is obviously 160, we say, does not have extraterritorial reach, and you will have seen that set out in depth in our statement of case at paragraphs 30 to 66, and the respondent has dealt with their view of it in paragraphs 4 to 9. Yes, I think I am giving electronic page numbers, I hope. 504 of our statement of claim and 546 of their other respondents. We haven't quite got there yet in the Bahamas, my lords, with electronic numbers, so let's forgive me. So in the courts below, the respondent really approached the question of jurisdiction solely on the basis that all that was required for to get leave under Section 160 was simply for the defendant to obtain leave under Order 11, Rule 8.4, to serve a interlocutory summons out of the jurisdiction. But in their statement of case now at paragraph 7, it seems they accept our position that really the prior question, which has to be determined, is of a true construction in Section 160, does it have extraterritorial effect? Now, the one case I will cite to you, my lords, is the case of Grouper Torres, which was a Privy Council decision reported in 2005 to appeals cases at 333, and really the decision of Lord Walker, and simply where he said, and that was in that the presumption against extraterritoriality as being long-standing and that it has appeared to have become stronger over the years. In the Bahamas, my lords, we have not yet embraced universalism or expansive jurisdiction like you have in the UK. I think you'll see in our statement of case we give a number of examples as to how the law has not changed in the Bahamas and is still rather parochial.
But I mean, I find it odd you say that in the context of the International Business Companies Act.
Well, that may be its
Surely
name.
the whole point of that is to be global in approach.
Well, I think it's to bring in foreign investment.
Yeah.
The question is whether or not getting in foreign investment and allowing someone to serve out is perhaps an entirely different question.
I mean, maybe, it was just your suggestion that you're parochial in outlook.
Well, that's certainly a good marketing campaign, yes, I would say. But I think even when you look at that act, I mean, we can come to it, but there's certain sections like 128 when you read that act, and I'm not focusing on it because I think that the Bankruptcy Act applies, but even when you look at that act, section 128, it seems that it's read locally because there's the power to arrest and seize the goods of a contributory if he's going to leave the jurisdiction, which sounds a bit odd for an act that is meant to have extraterritorial effect. And there's no power to serve out under that act either.
And can I ask, just to follow what you're saying about extraterritorial effect, I understood when you accepted the analysis proposed by my Lord Reed that you accept, in effect, these claims operate in two stages. One, there's an avoidance of a transaction, and then two, there's the property claim by the company. Is the transaction that's avoided here not a transaction in the Bahamas? It's the redemption of shares in a Bahamian company.
Well, that's an interesting question. I think I would say it is where the funds are received is where your cause of action would lie if you were going to look at the underlying cause of action. But
if one's looking at the sorry,
it is by statute clearly a statutory test imposed by the Bahamas. The question is, does the Bahamas have the authority to impose that test on a creditor who is outside of the jurisdiction or someone who was a creditor who's been paid off?
But if I may, going back to the second stage of my Lord's proposed analysis, which I understood you to accept, the claim then is for the company's property.
Yes, to be recovered.
But
Right.
that's just, would that just not be a claim by someone who happens to be in the Bahamas saying that someone outside the jurisdiction has their property?
Well, it is and it isn't. It is if it's deemed that the act is to apply to somebody outside the Bahamas. Because remember you have, and I'm not getting into Galbraith and Grimshaw, but that's a 1910 Privy Council ruling. Basically, the clawbacks don't have extraterritorial effect. And it's been somewhat criticized, and I don't think it's necessary that I get into that today. But there are two questions that arise. First, looking at the act, was it meant to cover this foreign or abroad? And even if it was, is there power to serve? Is there a gateway to get out of the Bahamas? And the second leg of our argument is really there is no gateway to get out, because as we will see from these earlier cases, they got out under quasi-contract. Quasi-contract, we all now is restitution. The law has moved on from quasi-contract and implied contract. It's now a restitutionary claim. That is not a ground that you can serve out under the Bahamas under Order 11. The Bahamas has the 1978 English Order 11. It has not moved on. By way of example, a case I'm going to take you to now, just to show you the difference of how Bahamians courts look at interpreting jurisdiction when it's moved on in the UK, is the Grouper Torres Meets Pearson case. So in that decision, which we'll come to, Sheikh Fahad, or I think it was Sheikh Khalid, who was a cousin of Sheikh Fahad, was being sued in London in the Grouper Torres litigation. He had settled some assets on trust in the Bahamas. So because we hadn't changed Order 11 and added M, as you did, I think in 1988, which was assets, because if there were assets in the jurisdiction, that created jurisdiction for the court, and you could serve out under Order 11. They needed to come up with a cause of action, so they sued the trustees who were holding the money, and they couldn't prove that it was proprietary money. So they sued the trustees, and then they claimed to get a freestanding Mariva, right? Or sorry, they didn't have a cause of action. They sued Sheikh Khalid trying to get a freestanding Mariva against the assets in the trust, because they had no cause of action against the trustees. The Bahamian court held that even though following Mercedes-Benz and the Susquehanna and the change of legislation in Section 37 of the English Act, which gave the jurisdiction, which verified that the jurisdiction is there to give a freestanding Mariva, the Bahamas would not do so, even though it was a financial jurisdiction. Freezing this money would have protected its reputation, because the court said you really need to guard. It is for the legislature to decide where is the jurisdiction, who decides the jurisdiction. And if I ask you please to take up, if I would, that case, it is at page 1340 in the electronic bundle. It is tab 46 in bundle 2 of the authorities bundles. And you will see these was three judges of the Court of Appeal, and the president at that time, Justice Gonzalez Cibola, along with Justice of Appeal Hall, and the third judge, who's for some reason not appearing in the heading, but I think was Justice Longley, who was in that? Justice Carey, Justice Carey and Hall. Sorry, Carey is there. So if I take you first of all to the ruling of the president, if we go to page 633 in that judgment, at electronic page 1346, and you will see from just below letter E that he says, nowhere in the Bahamian statute is there a comparable enactment to Section 25 of the English 1982 Act. And therefore, the conclusion seems irresistible that the Bahamian Parliament has not yet considered the public policy calls for a law reform in the shape of English legislation. The following question arises: could it be said where Bahamian Parliament, unlike its English counterpart, has admitted to reform the law by thus widening the power of the courts to grant Mariva relief, the courts may themselves, as a matter of inherent jurisdiction, affect the desired reform? To pose the question is to answer it. As a matter of first principles, the court may not arrogate to itself legislative functions. For this court to apply the a rule of law that is inconsistent with the Susquehanna without the authority of legislation to that end, simply because it considered desirable to achieve the result by Section 25 of the English 1982 Act, is an impermissible aberration from the judicial function. Then, my lords, if we turn over to page 637 of that ruling, electronic page is 1347. Sorry, 637. No, it's not that far. It is, yes. And this is the, again, it's the same judge, and we will see really if we start at the top of the, at letter C, you will see that the President says the proposals there concern foreign defendants irrelevant for the present purposes, but the principle which was upheld was the duty of the judge to resist temptation to legislate even in good cause. And then if we go to Justice Carey, who is at page 641 at letter H, which is in the electronic bundle 1354, he said, when Parliament enacted the Supreme Court Act 1996, it was no doubt well aware of the English provisions, but must have been taken to have deliberately omitted it. The consequence, the omission, is that the power of a judge in this jurisdiction is plainly less. That, it seems unnecessary to point out. He then says, if we turn over to 642, at letter D, which is electronic page 1355, no such power is conferred by the legislature in this country. Parliament was also aware of this enactment when the Supreme Court Act was passed in 1996. What we are being asked to give effect to is in England accorded by statute, not by inherent power of the court or by any applicable law. And then, the Lords, lastly, lastly at 1365, which is page 652, E to G, this is Justice Hall, who says, while I confess to a strong inclination to follow Lord Nichols and Mercedes, where I faced with the same facts, and embracing the views of Lequesne, President Lequesne in Solvalube, which I see to be identical to the policy pronouncements of the executive branch of the government of the Bahamas of preserving the integrity of the Bahamas as a clean financial center, I feel compelled to hold, as it is argued by Mr. Barnett, counsel for the appellants, that on the facts of this case, to hold Mariva relief in personam nature, of which I emphasized, could attach to the defendants who are trustees, would be for the courts to overreach and assume powers which are properly within the province of the legislature or the other rule-making authority. So the Bahamas remains a jurisdiction of which there is no freestanding Mariva. And I think supports my point that we're not exactly proactive in terms of expanding jurisdiction. But what's also relevant, my lords, is the view of the Bahamian Court of Appeal and how they approach the sort of mixed territory of where you have English legislation moving on, but Bahamian legislation standing still. And their view is, look, that is a matter to be dealt with by Parliament and not by the courts.
Can I just ask you, you've accepted that what's going on in law when a fraudulent preference is successfully challenged is that there is an avoidance of the relevant transaction, in this case the redemption of shares and therefore a consequent payment. And the effect of its avoidance is to put the parties into a situation where the recipient of the money has money to which it ought not to have, and the company, on the other hand, has failed to redeem the shares. That's the world we're in. And so a cause of action arises held by the liquidator. He has a cause of action to recover the money that was paid to the company. Yes. And I think it's implicit in your argument that that cause of action arose in Bermuda rather than in the Bahamas.
The reason I say that is I don't have an exact answer on that because, but I can tell you that it was considered in the case of Trustee of Russo, which we handed up, as well as Jokia. And the views taken there were that they kind of felt that it was a quasi-contract, so they fitted it under Order 11 under contract. But as I said, the laws moved on, and everyone knows that quasi-contract is now restitution. But what they said was, I think in Jokia, which was the judge in Jokia, I think it was, anyway, the judge in that case said, look, I don't understand how it's quasi-contract anyway. He criticized it, and he said, because it probably arises in the country where the funds were received. Now, the reason that I haven't overly examined it is this sense. It's really up to them to have made their case and come in where they come in under Order 11. They can't switch horses now. They're bound by authority that, you know, when you go into an Order 11 application, you're bound by which section you applied under. But I know the court might be disturbed and say, well, this can't be right that there's no way to serve out under Order 11 when we come to that. But what there is in the Bahamas is there is assistance under Section 122 of the 1914 Bankruptcy Act. Because the Gruper-Torres case, which I put in the bundle, which is the Gruper-Torres case, which went to the Privy Council from Cayman. And in that case, the bankruptcy trustee, who was Mr. Cliff Culmer, wanted the assistance of the Cayman court to do something he couldn't do in the Bahamas, but he got a request for letters of request. Now that legislation has been not directly through the Bankruptcy Act, but it is listed as legislation applying to the Bahamas, and it was done so in Cayman. Letter of request was sent, and they applied the Cayman law, and they assisted. So there's no reason that, particularly because these assets were in Bermuda, that a letter of request couldn't have been sent by the liquidator, obviously pursuant, because this is coming out of the bankruptcy jurisdiction, to assist in this claim. The other place they might fall under, they may argue that it's a permanent injunction. In other words, I want a mandatory injunction for you to send my monies back. But we're going to come to examine Order 11. But in my personal viewing of Order 11, I didn't see anything that I thought that it would fall under. In other words, that cause of action would fall within Order 11, because I think it probably is money hadn't received, which is a restitutionary claim. Sorry, that was a long-winded answer, but as I say, there is Section 122 of the 1914 Bankruptcy Act, which applies in the Bahamas. And if you look at the Gruper-Torres decision from the Privy Council, it is in the bundle, in Lord Walker's decision, you'll see it. I think it's around paragraph 15 that he discusses that. Now, having sort of laid that groundwork to simply say, you know, the landscape is different in the Bahamas than it is in the UK, and you've got to take that into consideration. My lords, I wanted to examine re-paramount because the respondent puts heavy reliance on re-paramount, and to draw the distinguishing factors of that case. First of all, which I'll come to in a moment, the sort of authority, the authorities to show at the time re-paramount was passed was after the Insolvency Act of 1986. That's when you could serve someone out of the jurisdiction under the Insolvency Act. In fact, it was as of 1962, there was an amendment which allowed service, a limited amount of service, but you could serve more than the debtor. Pre-1962 in the United Kingdom, or I should say England and Wales, you couldn't serve outside of the jurisdiction. What happened was there was an amendment to the rules which allowed that. The Bahamas has never had that amendment. So we have nothing like Rule 1212 in the 1986 Insolvency Act. We didn't have the updated 1962 rule, I think it's Rule 82 of the Insolvency Act then at the time in the UK. But by the time re-paramount is decided, this rule change has taken effect. And so this is one of the factors that weighs in the judge's mind is the fact that under that act, you can now serve out. So if we take a look at the decision, which is in tab 19 in bundle 1 at 903 is the electronic page. Oops. So, firstly, if I could take you, sorry, I'm just opening this. If I could just read, and this is a decision of the Vice Chancellor Nichols. If I take you to page 235, and he is discussing at letter F, the persons in respect of whom...
I'm so sorry. We're, most of us, operating on the electronic.
Oh, sorry, B 915.
No, thank you. Thank you.
Lawyers will have to tell me at the end whether moving to electronic bundles has been... Something about having something in your hand. At F, it says, it will have been seen from the above summary on its face, the legislation is of an unlimited territorial scope. To be within the section, a transaction must possess certain features. For instance, it must be an undervalue. And I just pause here. This case, again, is a transfer undervalue. Most of these cases are all dealing with slightly different things by analogy. This judge does mention fraudulent preferences, but sort of in passing as falling under the same scope. In the Bahamas, we have separate legislation for things that are undervalued. They were outside of the company's legislation at this time, or the IBC Act. That was, we had the Fraudulent Dispositions Act of 1991, which dealt with conveyances at an undervalue. It replaced, you know, there used to be the Elizabethan statutes of the Fraudulent Conveyances Act and the Fraudulent Gifts Act. And so even under that act, there's no power to serve. You would have to come under Order 11 somehow if the transaction was out of the jurisdiction. But in any event, if I read on, for instance, it may be an undervalue and made at a time when the company was unable to pay its debts. The company must be in the course of being wound up in England or subject to an administrative order or so on. If a transaction satisfies these requirements, the section applies, irrespective of the situation of the property, irrespective of the nationality or residence of the other party, and irrespective of the law which governs the transaction. In this respect, the section purports to be of universal application. The expression "with any person" merely serves to underline this universality. It is indeed this generality which gives rise to the problem. In these circumstances, one is predisposed to seek for a limitation which can fairly be read as implicit in the scheme of legislation. Parliament may have been intending to legislate in such all-embracing terms. Parliament may have intended that the English court could and should bring before it and make orders a person who has no connection whatever with England, save that he's entered into a transaction, maybe abroad and in respect of foreign property, and the utmost good faith with a person who is subject to the insolvency jurisdiction of the English court. Indeed, he might be within the section and subject to the orders, even though he had not entered into a transaction with the company, the debtor at all. Such an intention by Parliament is possible, but self-evidently, in some instances, such a jurisdiction or the exercise of such a jurisdiction would be truly extraordinary. The difficulty lies in finding an acceptable implied limitation. So the Vice Chancellor is clearly uncomfortable at finding that this is a completely open jurisdiction. What he then does is he does an examination of factors which he thinks are relevant to make his determination, because he does find in this ruling this has extraterritorial effect. But every one of those factors that he relies on, we don't have. So he says, and I'm going to have to get my learned friend to give me the digital page numbers, but he says, first of all, he finds, firstly, that there is a mechanism for repayment. We discussed that. And I think we cited that as well in our statement of case at 37. But sorry, the judge then finds that there is, that they have 1212, which basically cures. One of the things that the Vice Chancellor is concerned about is he's concerned about safeguards. And he finds that 1212 is an assistance in protecting against service out that is unjust, because you need leave. There is a process of showing that it is whatever the process under 1212. He also says that there is a discretion under the Act itself as to whether or not to give relief. There is no discretion under our Act. If it's a fraudulent preference, it's a fraudulent preference. And so that alleviates some of his concern in terms of finding that it's extraterritorial. The other thing is he does say, and he does examine the earlier cases, which I'm going to mention to you, and he says, all of those cases were dealing with mostly with issues of service, because those ones were, and he was saying that now we have 1986, we have a modernized code, and so and 1212 has resolved a lot of the problems about tying itself back to the bankruptcy rules. But what he finds is, he says, well, how can I say that this act is still extraterritorial? And what he finds is that two factors. The first is, he says, in England we have the power to wind up under the Act, we can wind up a foreign company. And so he's quite reliant on the fact that you can look for that to see that is another extraterritorial provision in the Act. So clearly it was to have that scope. We don't have the power in the Bahamas to wind up a foreign company. We didn't at the time. We only have had that power since 2011. And it's obviously not legislation which is before the court. It's later legislation, but it's only recent. So under our Act, there was no power to wind up a foreign company. The other peg that he hangs his hat on is he says that he makes a finding that that under the definition of I believe it's of a connected person or company, and I'm just trying to find the reference, but it defines, yes, so the reference is in the judgment itself, it's at page 237D, but he's dealing with, 917 of the electronic bundle, but he's looking at section 43511 in the Insolvency Act of 1986, and he says that under that, there's a definition that company includes a company whether incorporated in Great Britain or elsewhere. So he says, ultimately, he comes down, he says, look, this is not an easy decision for me, but because there's clearly two references in the Act that it's of extraterritorial effect, there is these safeguards now that we have under 1212 and safeguard under the section as to actually whether an order is made. I am comfortable saying that there is some limitations to this Act, and I'm happy concluding that any person means any person in the world. Now, what we say to that is, we say that the distinguishing factors are not existent in our case. We have the Bahamas, which is not the same as the UK or England and Wales in terms of the, I know I shouldn't use the word exorbitant jurisdiction, but the extraterritorial jurisdiction which it takes on. And none of the factors to which the judge relied on do we have. There's nothing in our Act to say that it should be of extraterritorial effect. And there's nothing in 160. In fact, it's tied back to the 1860 bankruptcy rules. Under those rules and that Act, the only thing you could do was serve the debtor out of the jurisdiction. That is Rule 63 of the rules, and the rules are in the bundles. At Bundle 1 at page 581, you'll see those are the rules, and the only rule with reference in all of them is page 595 of the record, but is Rule 63 allowing the debtor to be served out of the colony. So Well, Lords, I think paramount is very distinguishable, and it's probably helpful, it is helpful to understand paramount to see what the law was in England pre-1962, before this change. And we rely on several cases. We rely, first of all, on Reed Tucker, which was a judgment of Lord Justice Dillon, and that is at page 931 of your bundles. I'm not going to take you to it, but that is the case, I think, where they were dealing with the question of whether a person could be examined outside of the UK, and that's where the comment was made by Lord Justice Dillon that eyebrows would be raised to suggest that the 1914 Bankruptcy Act had extraterritorial effect. And that decision...
Can I just interrupt you?
Yeah.
I wonder if we're getting a bit sidetracked here. Cases like Paramount are to do with the construction of a statutory provision. They're looking at the statute and asking, does this statute have extraterritorial effect? And that's what you were about to take us on to, another example of a court asking itself, does this statutory provision have extraterritorial effect? We've already established that the effect of the statute that we're concerned with is limited to the avoidance of the transaction under which the payment was made. For the rest, it's a matter of common law what the consequences then are.
Well,
And
yes, it could. Well, that would be right, my lord, if you accepted my proposition that it wasn't from inception. Well, isn't the question this? Is it extraterritorial to start? Because if it's not extraterritorial, then it would never have jurisdiction over someone. You would never consider it to be a fraudulent preference if the person who received the funds was abroad. It just wouldn't fall within the definition. And the reason here's the reasoning for that. The Bankruptcy Act, so you look at the section and say, who was it to apply to? Was it to apply outside of the jurisdiction?
Can I just...
Yeah.
So Donald Nichols was looking at a section that referred in particular to persons.
Yes.
And to a jurisdiction with persons. If we apply his overall discipline to the section with which we're concerned, which I think is section 160, on the face of it about persons at all. It's about transactions.
Well, it's about
Very broadly worded. I mean, conveyance, mortgage, delivery of goods, payment, which I think is probably the relevant one for present purposes, execution or other act relating to property. And if one applies Sir Donald's discipline from Paramount to a different statute, of course this is, we're asking ourselves, well, can we read some territorial limitation into the phrase any conveyance ... relating to property?
And I say that you can, because the reason that you can is that it also includes any creditor, right? In other words, you're looking at the words any creditor under the section. Section 72, right? Because that adopts, 160 adopts 72 in the Bankruptcy Act. I think we went to 72, I'm sure we did, right? Which, just to make sure that we did, that is at tab 1, page 580. Right, that's the one you're looking at, right? Every conveyance, transfer of property. So this is from the Bankruptcy Act. So it says, from his own monies in favor of any creditor or any person in trust for any creditor.
Hey, which section is that?
72. So, in other words, the IBC Act directs you to this section and says if you're liable under this section, then you're liable under 160. So so what arises? The question that arises is, well, from a jurisdictional point of extraterritorial, what did they mean by creditor? Could they have possibly meant a creditor outside of the jurisdiction? Part of the analysis, we say, is obviously that they couldn't have, because if you're looking at because under the Bankruptcy Act, right, to be liable, it has to be somebody that that they have jurisdiction over, somebody that they can serve. So not only on the service basis, but it wasn't simply in 1881 when our act was passed, I think it's 1881, there was no concept of serving creditors outside of the jurisdiction. And that's why the bankruptcy rules don't have any provisions for service out. It just couldn't be that anyone was thinking of a creditor on an extraterritorial effect basis. And so, I believe that the test is what is your cause of action, provided you set it aside, but you've got to get to the person to set it aside first, the fraudulent, the conveyance or the transfer, in this place, the redemption. What I say is that the act itself, there is nothing in that act to read anything that's extraterritorial. I mean, remember, we're only focusing from the IBC Act itself, we're only focusing on 160. 160 directs us to the Bankruptcy Act. It directs us, 154 directs us to the bankruptcy rules. So whatever the ambit of 160 is, it is limited by the Bankruptcy Act and the bankruptcy rules.
Both Section 160 and Section 72 speak in language of preferring creditors.
Yes, they do.
Does that mean that it only applies if the creditor is within the jurisdiction, at the time when you make your preference application or at the time when the transaction originally occurred? How do you construct a limitation around creditor, which means that the whole section doesn't have extraterritorial effect?
Well, I think it would be like any of the other earlier cases under the bankruptcy regime, where you could serve, if a person is outside, they are outside. And from the day, in other words, if they haven't submitted to the jurisdiction, or they're not in the jurisdiction at the time that they serve, they are abroad, there simply is no extraterritorial jurisdiction. And because under the Bankruptcy Act, the only thing that you can serve out are notices. Notices letting individuals know that you are settling a proof of debt, a list of creditors, etc. The case, just to make good on that point, I think it's called Re Rathbone, which is in the bundle. Is it Re Rathbone? At tab 53, bundle 3, and that will be page, I'll just pull it up. What is it? Page 1445.
Just before we leave Section 72 of the Bankruptcy Act, you're really saying that the words "any creditor" are to be read as meaning any creditor in the Bahamas?
Yes.
Are you?
Yes.
I'm wondering why, because obviously either an individual or a fortiori an international business company can have creditors outside the Bahamas.
It can, but the scope of Section 160, which is to be a fraudulent preference, must be any creditor within the bankruptcy regime. Because if you look at 160, it directs you to the Bankruptcy Act. And you go to the Bankruptcy Act, any creditor under 72 is obviously someone who the Act applies to. The Act cannot apply to someone where there was no jurisdiction. In other words, if under the Bankruptcy Act you had no power to bring any proceedings against someone outside of the country, surely the wordings "any creditor" under that Act could not mean a creditor outside of the country.
That would mean that in a wholly domestic preference, where the preference had taken place in favour of a creditor who at the time was within the Bahamas and received the money in the Bahamas, providing he puts it in a suitcase, takes it on a boat, and gets out of the jurisdiction, I suppose, 12 miles offshore, then that wholly domestic preference would be out with the reach of the section.
Yes.
If I may, I rather question whether that's true even in a bankruptcy case. On my understanding, what would happen in a bankruptcy case is that the assets of the debtor all become vested in the trustee in bankruptcy. And then going back to the analysis that my Lord Reed has already put to you, would it not be a claim brought by the trustee in bankruptcy for his property
Well, it would be, but that would be a different type of claim. It would be a fraudulent preference claim being served out. And I suspect you would run up against Galbraith and Grimshaw, which is the 1910 Privy Council decision, which basically says clawbacks bankruptcy trustees have no extraterritorial jurisdiction when they start trying to get, I think that was a case in Scotland where someone had put a charge in before the bankruptcy trustee showed up, a charge on some property, and they said, well, too bad, because it doesn't apply. But what reinforces this, as sort of you'll see, even in Masry, they mentioned that Justice Mance at the time, was that, the lack of ability to serve reinforces that an act is not extraterritorial. And we haven't come to that yet, but there is no way to serve this.
But that's why I raised the question, even in the bankruptcy situation, is it really the case that the trustee in bankruptcy cannot serve outside the jurisdiction to recover his property?
Well, if he had a proprietary tracing claim, I suppose he could. If he's instituting a claim in the Bahamas to serve abroad, to claim that money back, he has to fall within Order 11. Because that is the Order 11 of our Supreme Court rules, is the only basis on which you can serve out and serve a writ out. You see? So what I'm saying is we have the Order 11 from 1978. There are very limited categories.
But
other than section, and a bankruptcy trustee, he could also do a section 122 application that was done in the Grupo Torres case, of which Lord Walker ruled in this tribunal, when they made a letter of request to the Cayman courts to assist. And that's how they assisted. So there is remedy. It's just not necessarily through a writ action.
right, but couldn't it be through a writ action, in fact?
Not unless you can find a gateway. And we're going to come to that, but I don't think there is a gateway under Order 11. That's different.
I see. Thank you.
So that's probably a convenient time to move on to Order 11. And the first case, perhaps, that we could go to is the Jokai decision, which is at tab 18, page 901. It's in bundle 1. And this was a decision of Vice Chancellor Brown Wilkinson. And really where I would like to take you to in his decision, this was a case, again, I think this case was commenced, commenced by notice of motion. The interesting part is Paramount, we're going to get to the procedure because they commenced this by summons, but in Paramount was commenced by an originating application. I think Jokai was a notice of motion, but Russo was by a writ. So all the cases that we've looked at, that we seem to see, all seem that this isn't some sort of interlocutory summons, which is another point that we take, but they all seem to be, and I think it's because you need that second cause of action we discussed of how do you get the money back, because that's not covered by the section. But if we go, please, to page 493, which is page 899 electronically, at letter G, is there any power to serve out? The textbooks state that the existing law is as follows: motions which either do not seek personal relief or seek personal relief against British subjects or foreigners who've acknowledged the jurisdiction of the court can be served out of the jurisdiction. Otherwise, motions which seek personal relief against persons outside of the jurisdiction who have not acknowledged the jurisdiction cannot be served. Then the citations are there. And then, however, Williams and Muir and Hunter on bankruptcy suggest that an amendment to the rule of 86 of the bankruptcy rules of 1952 made in 1962 may have altered that position. Before 1962, the law was undoubtedly decided in the sense stated above. The basis of the law was that there was no statutory power corresponding to Order 11 authorizing the bankruptcy court to assert personal jurisdiction over a person other than the debtor outside of England. See Ex parte Robertson. Henry Rathbone, which we have in the bundle, and Henry Alderson. Until 1962, Bankruptcy Rule 86 related only to service out of the jurisdiction on the debtor. There was no power to effect service or other process on anyone else. However, it had been decided if the relief sought in the bankruptcy was sought by way of writ, which came within Order 11, the court would give leave to serve out. In the case cited there is Russo trustee versus Russo, which we're going to come to. In 1962, the Bankruptcy Amendment Rules, 1962, substantially amended the Bankruptcy Rule of 86, which now reads, where any process or order of the court or other document is required by the Act or these rules to be served on any person who is not in England, the court may order service on him of that process or order or other document to be effected within such time and in such matter as it thinks fit, and may also require such proof of the service of that process, order, other document as it thinks fit. The wording of this rule is perfectly clear in general. It seems to me in terms to provide exactly that the power, the lack of which was the basis of the pre-1962 law, that service could not be permitted out. Accordingly, in my judgment, the court does not have a discretionary power to give leave to serve a notice of motion in bankruptcy out of the jurisdiction. Mr. Pollock, although formally submitting that this was not the right conclusion, was unable to suggest any reason for the 1962 amendment unless it was intended to give such power. And then he goes on to find that even with that amendment, it's still prescribed by Order 11. Now, I'm not going to read it to you, but, my lords, I just give you the reference, just for time purposes. But on 901, you will see that he does make an analysis between letter C, and it's of the actual decision, is page 495, letter C, and over at the top of the next page, B, he makes an analysis of whether there is what is the cause of action? And he criticizes Russo trustees, which found that it was a quasi-contract. And I know you're interested in that, so perhaps I'll just let you read it, although I'm mindful of my time, because we have a number of other submissions to make. So, my lords, I'd like, if I could, the last case really on this point to take you to is a case which was, we left out of the bundle by accident and was put in a supplemental bundle, trustee of Russo, so you should have it in the supplemental bundle. I don't know that we have an electronic page. Oh, it's 1762 if it was uploaded for you. So this was a case, slightly different facts again, because this is where bankruptcy and trustee is dealing with trying to set aside a settlement under section 42. But this is, the judge analyzes, Justice Dankworth analyzes the cause of action. And basically he finds that it is a quasi-contract. And you will see that, Lord Brown Wilkinson in Jokia criticized his decision. But the point, aside from that, is if I could take you to page 489, just to determine what is the effect of a declaration if one gets one, which we've been discussing. And I don't have a page number, 489, electronic. And just while my learned friend gets the electronic page, I'll read. 1764, 1765, just by letter C.
Which of the hard copy page?
That would be 489,
Thank you.
letter C.
Let's see, right.
He claims that and this is they're discussing what is the effect.
Sorry, can I have that page again?
Yes.
The electronic page.
The electronic page, 1765.
1765.
Yeah, so it's in the recent bundle.
Yes, I got the recent bundle. Oh,
We left two authorities. Well, one authority was not complete. There was a page missing, so we put it in again, and this authority was inadvertently left out. But if I read from just above letter C, and we may have extra copies here if you wish a physical copy. Okay. At 489. He claims that the transaction is void, or at any rate, that is not effective, and the monies are payable to him on different grounds. The transaction is said to be an act of bankruptcy under Section 1B of the Bankruptcy Act. As a result, the combined effect, I just want to make sure this is the bit I wanted to read. I apologize. I'm sorry. I think the bit I wanted to read is on 491, just below letter D. Counsel for the official solicitor, however, went on to argue that in the present case, there was no quasi-contractual obligation of any kind. That obligation, if it existed, on the part of the defendants to repay the money arose by reason of the enactment setting aside the transaction, which is impugned. I asked him to point out where the enactment said the money was repayable, but he contended that it was common form and when a transaction was set aside for the court in similar cases to order repayment. It is clear that there is no provision in any of the sections on which the trustee relies for retransfer of the property or repayment of the money with regard to a void transaction. Counsel for the official solicitor said, however, that the law implies such an obligation and that supports, therefore, his contention that it's purely a statutory right and not one which raises even any such shadowy matter as a quasi-contract. He referred me to Maxwell on the interpretation of statutes, in which there was a statement suggesting that where a statute produces certain results, what the author describes as a corresponding right is thereby impliedly given. I find it, however, difficult to see exactly what the author means by corresponding right, and it seems to me that the statement is not all specific. On the other hand, Crane on statute law contains a passage which strongly suggests the contrary is really the case, and it is true when setting aside the transaction is obtainable under statute. It is by reason of that result that an obligation is imposed by the law on the man who improperly has the property or money to retransfer it or repay it to the successful party in action. It seems to me that that is the true view. It is necessary for the statute in those cases to it is unnecessary for the statute in those cases to create any right of action for recovery of the money because once the transaction has been set aside, the property or money was wrongfully in the hands of the person who had it. And therefore, by operation of law, as stated by Lord Wright, Master of the Rolls in Brook Wharf and Bull Wharf Limited versus Goodman Brothers, became retransferable or repayable to the successful party. Therefore, it seems to me that the right to recover the money is not a statutory right in a case like the present. Is there a right imposed by law, which Chief Justice Lord Mansfield in Moses versus McFarland called a quasi-contractual right, and which the Privy Council in Bowling versus Cox have recognized as being within the description of a contract, inept though it may be. There is, however, one further point whether the right is something which made within the jurisdiction. So he goes on to find that corresponding right to get the money back, for a hadn't received or a quasi-contract, you fall under Order 11. But what we know is the law's moved on since then, and we don't really have quasi-contract anymore for these claims of restitution. There are claims in restitution. Restitution, there is no leg under Order 11. And I have in the bundle Westdeutsch Landesbank versus Islington Borough, which is a decision of Lord Goff, which is in there if you need, references to show that it's no longer called implied contract, that it's really a restitutionary claim. Now, having said that, it is our submission that given where the law was, given the fact that the 160 is tied back to the Bankruptcy Act, given that there was no law ability to serve out in the Bahamas, nor has there been, nor is there, and it was not until 1962 in England that one could do this, that there is no reason for this Section 160, due to its limitation by 72 of the Bankruptcy Act, to be considered to be of extraterritorial effect. And there is no reason why, where the 1986 Act was passed in England 14 years before the 2000 IBC Act, and Paramount was decided 7 years before, there's no reason to assume that the Bahamian Parliament didn't know about those changes and didn't know about that case, as they said in Grupo Torres. If they wanted to make the amendments to the legislation, they would have, but they didn't. They tied it back to the Bankruptcy Act of 1860. Now, it is suggested, that it's an international business company. Well, that, in my submission, is probably a good way to market the selling of those companies. But also, it isn't necessarily true that someone would want to invest knowing that once because most these are used quite often in mutual funds, and this was a mutual fund. And if I was a punter in a mutual fund and I'd been paid my money, I would have been very upset to find out 6 years later that somebody could come and tell me that I've got to pay that money back. Especially if I lived in a country where they didn't have any sort of concept of clawbacks. And so it's my submission that simply by the reference, as the respondents try and say, to international business company doesn't take us anywhere, because Parliament would have been clearly aware of all the legislative developments in the UK, and they decided not to follow those and to leave us where we were. So if I can now move on, I'll leave that behind, which is sort of the extraterritorial scope of the Section 160. So the question then is, well, what rules apply? Now, you've heard my submission that 154 applies, so I'm not going to develop it anymore, because I think 154 is clear, and it's clear to the creditor. I don't need to go in depth on that for purposes of time. That's 154 of the IBC Act, which says the bankruptcy rules will apply in relation to a contingent creditor. But the Court of Appeal erred in any way, because somehow in their decision, they, along with the respondents, said Order 11 is applicable. But we say that Order 11 is not applicable in any event. And the reason that Order 11 is not applicable is because of the rules of the Supreme Court, Rule 1, Rule 2. And I'm just going to, because I'm going to cover all three grounds together, I'm just going to tell you what they were. So the first is ground, I mentioned ground 2, that 154 applies, and the two fraudulent preferences, and I say that the Court of Appeal erred in their judgment at paragraphs 89 to 93. The second ground that I'm going to address globally now is that the Court of Appeal erred in failing to consider whether the rules of the Supreme Court were disapplied in relation to winding ups, and that's because of Rule Supreme Court 1, Rule 2, which says they don't apply to winding ups, and 3, and the odd thing is the court, there's no reference to give you in the Court of Appeal judgment because they simply didn't address the argument. They didn't even refer to the rule, even though they were addressed on it. And then also on ground 6, that the Court of Appeal erred in law when finding that the compulsory winding up proceedings, the petition fell under Order 11, Rule 3. And that you can find at the Court of Appeal's judgment at paragraphs 37 and 38. So the service out point, as I have said, is inextricably linked to the territorial point. bankruptcy rules, which we say apply, contain no ability to serve out. So the respondents, to try and get around this, sought to rely on Order 11, Rule 8.4. And they served an interlocutory summons under Order 11, Rule 8.4. Now, the difficulty with that is obviously we say the rules don't apply for a number of reasons. One, the bankruptcy rules apply. Two, if we look at Order 2, Rule 2, it doesn't apply, and I'm going to take you to that. Order 1, Rule 2, which is at tab 4, page 669. Bundle 1. And so you will see Rule 2.2. It says, these rules, Rule 2.2, these rules shall not have effect in relation to proceedings of the kind specified in the first column of the following table, being proceedings in respect of which rules may be made by enactments specified in the second column. So I pause there, and that's at 669 of the bundle. I pause there to point out that this says two things. One is, if you're in the first column, whatever those type of proceedings are, the Supreme Court rules do not apply. And secondly...
Sorry, just on that, isn't that provided there proceedings in respect to which rules may be made under the enactments in the second column?
No. What it says is, it says firstly that they don't apply, period. But it says that there may be rules made. It doesn't say they will be. So there might be rules made. But if they're in any of that type of proceeding, whether there's rules made or not, they don't apply. So if you turn it over, you see 1 and 2. 1 is bankruptcy proceedings, and 2, proceedings in relating to the winding up companies. Now the respondents say, oh, you know, it says the Companies Act, it doesn't say the IBC Act, but the point is that the enactments may make rules. They may not, they may. But if you fall within the proceedings definition, and it doesn't say proceedings under the Companies Act, it just says proceedings relating to winding up, the rules simply don't apply.
Is it not right that there is no power under the Companies Act to make rules in respect of windings up under the IBC Act?
There is no power under this particular company. Yes, that is correct. There was, my lords, which my learned friend will point out, there was in earlier pieces of legislation in the 1995 IBC Act, there was a rule, I think it was 95, or section 95, which adopted the company's winding up rules mutatis mutandis. But that was left out, expressly left out in the 2000 legislation. And what we see was that there was, in fact, a reference, as you see, the bankruptcy rules. Now, obviously, the reference to the bankruptcy rules...
Well, could I just put to you the point that was troubling me so that you can deal with it?
Yeah.
If one reads the words in brackets in sub-rule 2.2 as qualifying what appears in the first column of the table, and we know that, I think you've just accepted, that there's no power under the Companies Act 1992 to make rules in respect of winding up of companies under the IBC Act.
Yes.
Then would it not follow that in fact Order 1, Rule 2.2 does not have effect to exclude the operation of the rules of the Supreme Court in relation to winding up of the IBC Act companies?
I would accept, I'd have to accept the way you put it, if that was correct, that that was true, except for a couple of factors. We have section 154 of the IBC Act expressly applying the bankruptcy rules to the fraudulent preference. So you wouldn't even get here, right? Because there have been rules, and where it says there, you see that the bankruptcy rules, we would probably fall under the bankruptcy rules in the Bankruptcy Act, which is cited. In any event, even if we got that far, you're going to see, we've looked at it at all levels. You're going to see that even under these rules, they haven't satisfied what they'd have to do under these rules, and I'm going to come to that.
Certainly, yes.
But I don't read it that way, my Lord, and I'm hoping that on reflection you'll read it the way I do read it, but I see it as one saying shall and the other one saying may.
The possible way of reconciling the shall and the may, that the court doesn't deliberately legislate to create a procedural vacuum, and the reason for the exclusion of these rules lobster barrel from application to one of the types of proceedings in the first column of the table is because whether the rulemaker has done so or not, there is scope for making procedure rules about those precise matters in some other piece of legislation.
There is scope. There is scope. There is scope. And, the IBC Act 2000 is quite broad in the sense, if you read it, if you read the whole thing, and I'll get the reference to the sections, but there are a number of powers of the liquidator set out there. There are a number of duties of the liquidator, a number of applications, including examinations and so forth. They're all within the Act itself. So it's not necessarily true that just because there aren't rules, there aren't rules. By way of example,
But why wouldn't the relevant rules, if you don't get the benefit of Order 1, Rule 2.2, not the rules in the rules of the Supreme Court?
Well, that may be for everything but a fraudulent preference. Because remember, I'm relying on 154 to say that.
I see, but that's, 154 is your argument that actually it's all the bankruptcy rules. But I was understanding that you're addressing us on Order 1, Rule 2.2 on the footing that you don't succeed on that argument.
Yes, then you don't get to these rules.
Yes.
And so, my argument would be simply that I think there is enough scope of the duties or the Act gives powers, broad powers under the IBC Act to the liquidator, including getting accounts from directors, examinations, etc. And you'll see those, by way of example, sections 136F, 127, 126. So if you have a look at those, you'll see that it's not as if that this is sort of the position where there's absolutely nothing to guide a liquidator. There's quite broad powers there. So, but I take your point. But I don't necessarily agree with it, and I'll move on, Lord. So then we get to the issue that arises is they say, assuming that I am right, they say, but we do get back to the Supreme Court rules, and how do we do that? We do by Rule 101 of the winding up rules. And so if we go to the winding up, and we say the winding up rules don't apply because they're not adopted anywhere, and there's nowhere that they apply under the IBC Act, but they say they do. And so, all right. Sorry, my learned friend has just pointed out, I should take you to the case of Mace Builders, just to show that it's the law of bankruptcy that applies to make good on that point. That is at tab 12, page 823, and it is a decision of Justice Scott at the time. And in this case, Mr. Alan Steinfeld, QC, was by analogy trying to get the court to agree, I think, that Section 3221 of the Companies Act was similar in jurisdiction to Section 320 in that it incorporated the Bankruptcy Act. And really, it's just the finding of Justice Scott at page 470, which electronic number is 834, which he says that, and that section 320 is the same as ours. It was a fraudulent disposition section, I believe, or fraudulent preference section, which adopted the Bankruptcy Act. And you will see at letter G on page 470 of the case and 834 of the electronic bundle, he says, Mr. Steinfeld's analogy with section 320 is not, in my view, an apt one. Section 320 incorporates the law of bankruptcy and declares the transaction of fraudulent preference shall be invalid accordingly. So I just put that out there because remember I had submitted that section 160, when it brought in section 72, it was adopting the entire law of bankruptcy, and that is whether you could serve somebody under the Bankruptcy Act as well. So getting back to where I was they are seeking to rely on 101. And we can find that at tab 3, which is page 640, is the beginning of the Companies Winding Up rules, which are under the Companies Act. And if you look at page 668, it says at 101, in all proceedings in or before the court or any judge, registrar, or officer thereof, or over which the court has jurisdiction under the Act and the rules, where no other provision is made by the Act or rules, the practice, procedure, or regulation shall, unless the court otherwise in any special case directs, be in accordance with the rules and practice of the Supreme Court. So she says, well, you know, they don't apply, but clearly the legislation says they do apply. Now, we have two answers to that. The first is that the Companies Winding Up rules don't apply anyway to an IBC. But the second is case law, the decision of Anglo-African Steam, I'm just going to find that. Yeah, what tab? Tab 17, which is page in Anglo-African Steamship Company, which is page 886, which is the decision of Justice Kay. It's a long-standing decision, which I've seen quoted quite often. And so what had happened here was, in this particular instance, was there was a Joint Stock Companies Act of 1884, and under that act, it said that the general practice of the courts shall be the practice. That act was repealed, and the act that replaced it, which was the Companies Act of 1862, did not have such a section. And it was argued that that practice still applied because that was the former practice. And the court held, firstly, Lord Justice Cotton held in the Court of Appeal, I guess this went to the appeal, at page 350, a couple of lines down, he says, the application is attempted to be justified by the words of the 170th section of the Companies Act 1862, which in cases not provided for by the rules to be made under the Act reserves the general practice of the Court of Chancery, including the practice in use in winding up companies. But in my opinion, this is not a question of practice, but jurisdiction. Whether the court has power to serve notices of an order on persons resident abroad so that the order may be enforced against them when they come to this country. It is said that leave may be given, saving all the rights of the person served. But if what is done is wrong, in my opinion, the court ought not to do it, leaving the person served to take an objection, which the court ought to make itself. And then you will see, and we turn the page over, Lord Justice Lindley, a few sentences down, the appellant relied on the Joint Stock Companies Act and contended that under the 108th section of the Act, the court was unable to serve persons out of the jurisdiction by post. This power has been reserved by 170 of the section of the Companies Act. I doubt whether the major premise is sound, for the effect of the Act of 148 is not to give power to serve notices out of the jurisdiction, but to provide that in cases where such was right, it might be made by post. It's only reformed the method of effecting service, but the question in this case relates not to the method, but one to right of service. I cannot find a right given either by the Act of 1848 or the Act of 1862. Certainly it's not given by the rules of 1883. And then in Lord Justice Lopes, in the last sentence, or penultimate sentence, in my opinion, what we're asked to do in this case depends not on practice, but jurisdiction, and it's not covered by the section. So what this case, we say, is authority for is, even if they could rely on 101, 101 can only help them insofar as its practice. It cannot help them insofar as its jurisdiction. So they can't go back to the Supreme Court rules to try and create jurisdiction over the appellant.
Sorry, I'm slightly struggling with that. Because 101 talks about cases over which the court has jurisdiction under the Act and rules.
Under the rules, right? Yeah, what we're saying, look, so the way they're using 101 is they're using 101 to say if my interpretation of 2 Rule 2 is correct, they use 101 to say we can still get back to the Supreme Court rules. And I'm saying that you can't do that because you can't go back to procedural rules to create jurisdiction, which is how I read the Anglo-African steamship case. Also, also, if you look at 101, again, sorry, I asked you to take that up. If you actually read 101, it's quite clear. It says, the wording of 101, it says basically in all proceedings in or before any judge or register officer or over which the court has jurisdiction under the Act or rules. Well, the Act and the rules are defined as the Companies Act. So the reference is and the definition of, under the Companies Act, of company is a company incorporated under that act. And if you look at the rules themselves, if you go to the definitions at the beginning of those rules, you'll see that it defines the act as meaning the Companies Act. And proceedings means proceedings in the winding up of a company under the Act. So these rules don't help them in the sense of they don't apply to an IBC for 2 reasons, as I've said. One is they shouldn't be allowed to create jurisdiction under Order 11 to go back, and secondly, they only refer entirely in their reference to a Companies Act company. And they're limited. They don't have scope for including other companies.
But if it's if winding up Rule 101 doesn't apply because it's a matter of jurisdiction and not practice, does not Order 11 apply, which deals with jurisdiction?
Right. So the reason that I say 101, what I say is you're unable to get to Order 11 by 101 because Order 11 is clearly a jurisdictional is clearly the jurisdiction of the court. So, in other words, you can't use the rules according to the Steamship Africa case, reference to other rules to give the court jurisdiction in a case that wouldn't have.
Your next argument is, well, the winding up rules don't apply anyway,
Right.
so put them on one side, one
Right.
goes straight to Order 11.
Let's go to Order 11. So then we get to Order 11. Thank you, lady, moving me along. We get to Order 11, and so the argument under Order 11 is, their argument is primarily that they came under Order 11.8.4, and you'll find Order 11 at page 683 or tab 4 in the bundle. Tab 4, you will see it in the bundle. And they say that they came under And the Court of Appeal said that they came under order, this is what they applied for in the summons, and got an order under Order 11-1. Sorry, 84, Order 11-84, which basically says, subject to Order 66, Rule 4, service out of a jurisdiction of any summons, notice, or order issued, given or made in any proceedings is permissible with the leave of the court. So they trotted along to court, and basically, under their interpretation, when they made their application, you could serve any summons on any third party by simply applying under Order 11-84. There were no limitations. Subsequently, this court, they've agreed that perhaps there are limitations, but they say Section 160, provided you fall within 160, you've set aside all the limitations. We say that Order 11, Rule 1.4 has to be read as being subject to the categories of Order 11, Rule 1. Because it would be extraordinary that a person abroad could just be served with a summons in a winding up that they didn't even know was going on. You know, of course, just procedurally, the summons is, if you just serve a summons, there's usually a shorter time for appearance, et cetera. It just isn't geared to bringing a claim. And as I have said, if you accept, as I say is right, is that there is no power of the court to reconvey, you must have a cause of action. That cause of action of money hadn't received needed to be pleaded out. It's not something you can just stick in a summons and say, pay me. And clearly, Order 11, Rule 1 is there to protect people abroad and in terms of, to let the court know what is an extraterritorial jurisdiction. And to make good on that, I'd just like to take you to a couple of cases. The first case is called, where is it? Okay, where is it? Tab. And I apologize, but as you can see, I'm very good at I was going to say at ruining the English language, but generally it's other languages that I have problems with. But this is called reactibologit Robertsfors, which is at tab 16, page 875. So this decision was on the scope of order, the predecessor to Order 11, Rule 8.4, or 11.8.4. And what they said was, when it was originally put in, that you must read it, and this was a decision of the Chief Justice, well, actually, it was I think there were two judges in this case, or three judges, and the decision was that you must read it as being subservient to Order 11, Rule 1.
This was then Rule 8A, which we
8A.
find in the footnotes.
Yes, which is in the
729.
footnotes. Yes, and the footnotes is on page 729. And so you'll see the Rule 8A at the bottom, which talks about serving a summons out of the jurisdiction, et cetera. And in the decisions, just finding the language that says it was restricted, and if you give me a moment, I just need to find my references in my notes. Sorry? 735, yes. So it says, I guess, if we look at first of all, the Chief Justice's decision, he says, I am of the opinion in order to confer jurisdiction, the grant of leave at the top of the page, 735, for service out of the jurisdiction of the notice to set aside and award circumstances which service out of the jurisdiction of a writ could not be allowed, much clearer language than anything that occurs in the provision Order 11 or of any other order to which our attention has been called will be required. In my judgment, the service of a summons, order, or notice contemplated by Rule 8A of Order 11 is subject to the limitations which surround the service of a writ. And so he ties it back, obviously, to Rule 1. And then Justice Pickford says at the bottom of the page, I do not think think that Rule 8A was ever intended to give, or does give, a right to grant leave to serve a notice out of the jurisdiction when leave to serve a writ could not be given. And it follows, if leave could be given to serve a notice in the present case of the jurisdiction, it must be founded upon one of the matters which are mentioned in Order 11, Rule 1, as a right to have a writ served out of the jurisdiction. And then lastly, Justice Coleridge at the bottom, Rule 8A of Order 11 is only supplemental to and not independent of the remainder of the rules in the order. The Lord Chancellor has not applied Rule 8 to France and is therefore inapplicable to persons ordinarily domiciled in France. The respondents must therefore bring themselves within Order 11, Rule 1. Now, that decision was recently considered, well, when I say recently, was considered in the ruling by Lord Justice Mance in the Oceana case, Masry, which we'll find at tab 13, page 836, I think it is. And this was dealing with, I think, where there was jurisdiction over a company, and the facts were slightly different. They were looking to examine the director of the company who was out of the jurisdiction. But the judge did, Lord Mance did have a chance to deal with this particular issue, and we will see.
So sorry, can we have a electronic page?
Sorry, electronic page. The beginning of the case is 836, but he dealt with it on 851, and he also dealt with it on 852. So at paragraph 32, he says, the second line down, thus in I'll say Roberts Fors, La Society Animes, where the Court of Appeal had to construe Order 11, Rule 8A, made in 1909 to extend the powers to serve out a summons, orders, and notices. The court held this power was only exercisable in situations where the service or writ was permissible and so did not cover a summons to set aside an arbitration award. There is no suggestion that heads of Order 11, Rule 8 were anything other than exclusive. Order 1191, which replaced Order 8. And I should say in England, your 9.4, of course, your 9 is the same as our 8, confirmed that the exclusive nature of the heads of jurisdiction to serve out provided by Order 11, Rule 1. And then he deals with it again, where he says, at paragraph 35, Mr. Salzado also referred to the dicta of Justice of Appeal Gallagher, and on one view, Justice of Appeal Martin in Statton versus Walton, which is a Canadian case, supported the view that the British Columbia equivalent of Order 11, Rule 8 was not subject to the restrictions of Order 11, Rule 1. The dicta does not appear to have been necessary for the decision. Gallagher, Justice A, made clear that the case had been argued, and the Justice of Appeal McDonald decided the case on the basis that the relevant obligation arose within the jurisdiction. And so within Order 11, Rule 1E now, CPR 626, Mr. Salza relied on Littleton Settlement Trust as a case where the Court of Appeal upheld an injunction against Mr. Liddell, who was not a party to the proceedings and who had taken her children to the United States. But the Court was careful to distinguish in Roberts Fors on the ground that Mrs. Liddell was domiciled and ordinary resident in the jurisdiction. Lord Justice Green agreeing with both judgments that there was accordingly an independent head of jurisdiction under Order 11, Rule 1. The case therefore supports rather than undermines Mr. Corey's scope. So essentially, Lord Justice Mance also held that that particular rule, which is in the English legislation, is subordinate to Order 11, Rule 1, meaning you must come under Order 11, Rule 1. Now, I should address, and also paragraph 37, I'm reminded by my junior, is relevant in that, what tab was that? In that that's electronic page 853, that Lord Justice Mance stated that although there may have been a kind in the Victorian rules regarding service out of the jurisdiction, the continuing absence in modern rules of any provision enabling service of an order under CPR Part 71 is both consistent with and, in my opinion, supportive of the view that CPR 71 was not contemplated any more than its differently worded predecessors as applying to officers out of the jurisdiction. That is at 853 paragraph 37. So if we then, well, Lords, I would just say that I've addressed the issue that there is no, well, what the Court of Appeal had held was they felt because it was a petition under Order 11, Rule 3, that a summons under that petition could be served out with no restrictions. The difficulty with that argument is that a petition under an IBC, there is no reason to serve it out, because petitions are served on the registered office of the company. The Bahamas, under this act, did not have the type of legislation where you could bring an oppression suit or force the purchase of shares, so you need to join in somebody else. There was no reason to serve a petition out. Section 66 of the IBC Act says you can serve the registered office, the registered agent, with any document. So a petition would never be served out of the Bahamas. So I think that they were mistaken in that view. I think to bring this claim, they also didn't accept or didn't address that there's two claims here in any event. There is, even if you could say you had a claim for a fraudulent preference, we've discussed, there's a secondary claim for payment. And that would need to fall under Order 11, even if you could say because this was a summons in a petition, you could serve it out, which I find astonishing, but if that's the proposition is accepted, you still would need that secondary claim to serve that out. If you look at Order 11 and our Order 11, you're going to see, and you don't need in terms of today to worry about which head it would have fallen under. I don't think that there is one, but it may have fallen under, as I said, a mandatory injunction, or they certainly could have got assistance under Section 122 of the Bankruptcy Act, which is judicial assistance, send a letter of request to another jurisdiction. But I don't think it falls with any of the heads. But the point is, they would have had to identify the right head. They can't come back to court subsequently, and the authority for that is in the bundle, is I just got the name of the case, my lord. Huh? Oh, Parker and Schuler, which is a 1910 case, which has been cited in a number of the decisions. But essentially, if you make an application under Order 11 on a specific ground, you can't subsequently come back and say that you're coming under a different ground. At page 874. Now, I'm not going to take you to the case, but my learned friends have somewhat tried to do that, my lords, in this sense. They now say, well, maybe you could treat this as a originating summons if we're wrong in their skeleton, and they say we would come under F, a quasi-contract. Well, we say you didn't identify F. F isn't right anyway, but it's not a quasi-contract, but you can't come back now and have a second bite at a cherry. The other thing they do is they identify Order 11, Rule 1-2, which says that you don't need leave where there's any enactment, etc. And I rely simply on that in the Oryxium trading case, which is at 854 of the electronic bundle. There is a discussion in there of the Ree-Harrods case, and I think that, if I'm not mistaken, that Lord Briggs was in that case. The Ree-Harrods case. And basically what Ree-Harrods said was to fall within that section, you have to, the Act has to specifically say in the wording that it's for service on people abroad. It has to identify that there are people abroad. And, yeah, and that, I've given the reference. And you're going to see in there that Lord Justice Lewin in the Oxford case, he distinguished it because but we have the same provision. He distinguished it on the basis that Lord Justice Dillon was focusing on the words notwithstanding in the particular section, which allowed leave out where it was cause of action by virtue of enactment. We have the same wording. We have the same statute. So we rely on Ree-Harrods to say.
Sorry, I'm not following you. We were being referred to Oryxium.
Yeah, but in that decision. In that decision.
Yes, but what's the tab for that?
Oh, sorry. The tab number of Ree-Harrods is, and I'm sorry I'm rushing, I'm just conscious of the time, is tab 14 at B1.
Yes, I see.
It's page 846.
And then you use that as a way into Ree-Harrods.
Yeah, because there's a discussion in there by Lord Justice Lewinson at paragraph 39 around paragraph 39 of Ree-Harrods.
Yeah.
And Harrods basically said, if you want to come, as they're now trying to say, if you want to come under Order 11, Rule 1.2, you've got to, the enactment specifically has to identify that you have the ability to serve out.
Yeah.
Okay? The other thing I point out is, this argument, if that was the case, if they didn't need leave, why are we here? If they could have just served it out. Why are we here? And this is a point that was not taken below. It's a point that has just been raised in their submissions. So I rely basically on that point on Parker versus Schuler, that they can't change their ground now. They didn't raise it below, and in any event, the enactment isn't sufficient for them to fall under Order 11, Rule 2. Now, quickly, I would like to discuss the question of the level of the evidence. I think it's accepted that you have to show a good arguable case. The cases are in our bundle, and I'm not going to revisit them in terms of, on an Order 11 application, what level of proof you have to bring, but you have to have a good arguable case. In a fraudulent preference claim, one must show that the payment was done with a view to prefer. The dominant motive must be the intention to prefer. The support for that contention you'll find in the House of Lords decision of I'm just finding the name, was it Pekin? I'll come back with that name momentarily, but so essentially you have to establish your case. They didn't even plead a case. The only case that they pleaded, you'll see at the liquidator's affidavit, which you can find in bundle in the appeal documents at page tab 9.
Yes.
It's a tab, sorry, it's not tab 9, that's Damien's, it's tab what? Tab 5, page 27. So if you look at paragraphs 5 and 6, this is the extent of the claim that was put before the court. It says at 5 and 6, approximately 2 months before the commencement of the liquidation, the company made a redemption payment in the amount of $13 million to one of its investors, namely ZCM. The company is advised by its attorneys and believes that pursuant to Section 160 of the International Business Company, ZCM's payment is deemed to have been an undue and fraudulent preference, and the payment therefore invalid. As a result, the company filed the summons. That's it. So the cases which you'll see in a good arguable case, you can't say that's your belief. There's no pleading of a dominant intention or a view to prefer. They also know that it's an agent. And as we're going to see, in the case of Re-Morant says that section that talks about trustees, section 72, where it says a creditor or a payment to his trustee, doesn't apply to agents. Now, what he does say in Re-Morant, which you'll see at tab, where's Re-Morant? Re-Morant, which is at tab 52, which is page 1442. And this is a decision of Justice Lawrence, PO, I'm not sure what that stands for, but 1923 decision, which is examining is an agent liable under this section. You'll see in the head note at 1439, in the last sentence of the first paragraph, a payment made to an agent on behalf of his principal in the ordinary case is not a payment in favor of a person for a creditor within section 441 1 of the Bankruptcy Act.
But if ZCM is a bare trustee and therefore the owner of the legal title, isn't it the creditor?
No. I mean, what this case says is basically if you're a nominee, if you know, well,
See, it struck me that this seemed to be a case about agents for collection, where the obligation is to the principal, which is being discharged. It's just discharged by putting the money into the hands of the agent.
yes.
Whereas in our case, ZCM's a bare trustee is the owner of, let's call it a debt owed to it, and that debt is discharged by payment to it.
Well, we don't agree that it's the owner, particularly where the company was aware that everything was held on the account for the benefit of American Express.
But I thought that you'd agreed before that that just meant that it was a bare trust relationship.
It's a bare trust, but in other words, it's not a trust with, as with this case on agencies, it basically says, look, if it's a bare sort of agency where you don't do anything, the act isn't applicable. But there's another case in the bundle which makes the point in terms of trusts, and that is the decision of Queen's Counsel, where's that decision? Huh? What's that? 38 Buildings, Saunders versus Sims, which could have been a Bahamian case because those are both Bahamian names, by the way. That's at tab 55 at 1462 of the electronic bundle. Now, the facts are different in this case, obviously, and really they're looking at avoidable preference under 239, where the trustee sought determination of a question where a creditor of the company and a person connected with the company. But the judge did, in this case, examine the issue of sort of bare trustees and full trust. And at page 205 or 1466, you'll see that the counsel in that case around letter C and D basically relied on some cases to say that the court looked to the equitable rights and not merely strict legal ones. And then if we turn the page, you will see what the judge ruled at the bottom of 1467 or 206 in the report. It said, the authorities which show that in an insolvency context, the court is prepared to look at equitable debts and liabilities and not simply legal rights, go nowhere near far enough to justify his proposition. The cases cited deal quite clearly with cases of nominee legal owners or bare trustees. In such a situation, the law will look through the bare trustee to substance of who is the actual creditor. That is a very long way from the present case where there's a complex trust and not a bare trust, and the beneficiary rights against the trustee are not a right to require a transfer of the asset in question, but merely a right to do administration. So there's some support there for the proposition that just as in re Morant it applies to an agent, it applies to a bare trustee. But the issue here is a simple one, is they didn't even plead that fact. They didn't tell the court. If they were going to say that we were, all they said was there was an amount of money paid to ZCM. They didn't say that there was a fraudulent preference. Under the agency case of re Morant, they didn't say that we were involved in some conspiracy. There's no facts of which to get leave. There's no good arguable case. So, and also, the case on dominant motive is Pete versus Graham, which it was at Grisham, which is tab 58, and I'll get you the page number in the electronic bundle, but that's the House of Lords decision. So they, my lords, they didn't get over the bar. All they said was we paid this money to these people, and the company went under 2 months later. That isn't sufficient. So if I could just take you back, my lords, and I want to wrap up in the next 5 minutes, so I'm over my time. If I could take you back to Order 11, which is at tab 4, Order 11, Rule 1, page 676. And just to highlight to you how limited the scope is of our Order 11, which doesn't include even things like trusts, assets in the jurisdiction, et cetera, which was, in England, even before you had the CPR, Order 11 had been greatly expanded. But you'll see it relates essentially to land in the jurisdiction, deeds or contracts liability situate within the jurisdiction to be rectified or construed against a person domiciled or resident, and to do with an administration of an estate of a person who died domiciled, the execution in relation to property or trust in the jurisdiction, writ is brought to against the defendant to enforce, rescind, or dissolve and all otherwise affect a contract. And this is the one in Russo that they came onto under quasi-contract, which we say is no longer applicable. If an action begun by writ is brought against the defendant in respect of a breach committed within the jurisdiction of a contract, again, not applicable. If an action is begun by writ is founded on the tort committed in the jurisdiction, not applicable. If the action is begun by writ for an injunction, they may have been able to argue that. Of course, they didn't. If an action is begun by writ properly brought against a person served within the jurisdiction, inapplicable. If the action by writ in relation to a mortgage, property, etc., not applicable. If the action is in a probate. So there are very limited circumstances. The Bahamas is still that way. There is no basis under Order 11 in which to get leave to serve out of the jurisdiction. Last point, really, that actually, I'll probably leave that for reply. Lords, unless right now I can give any further. Oh, sorry. Oh, so just, well, Lords, in conclusion, Section 160 does not have extraterritorial effect. The Bahamian Parliament could have legislated for extraterritoriality. It had the UK example in 2000, but it elected not to do so. It's not for the Privy Council to legislate where the Parliament has not done so. Even if Section 160 does have extraterritorial effect, the Court of Appeal wrongly abrogated its responsibility by failing to ensure that if the foreign defendant is subjected to the jurisdiction, that there's proper grounds to do so. The respondents failed to demonstrate a good arguable case on the gateway or a serious issue to be tried on the merits. Yet leave to serve out was given. We say the Court of Appeal was wrong to do so. Its order should be set aside and the summons dismissed. So I apologize, my lords, because we went through that at quite a haste, but there was quite a few topics and perhaps we didn't allot enough time, but I think the lords have managed to grasp my points.
Yes, I don't think that I'm encouraging you to take longer, but you do have more time if you need it.
Well, there is perhaps one other point I could address. Although I have gone through most of my points, my lord, I did want to address what my learned friend has put as connecting factors, and only because there is a case in the bundle, and I'm not sure that whether she knows the point I'm going to draw from the case, because obviously she filed her skeletons after I did. So one of the connecting factors, and we disagree with all of the connecting factors that she cites, because we don't think they are connecting factors, but one of them is that she claims that there was a there is a governing law and I guess jurisdiction clause under the subscription agreement.
Yes.
So my answer to that is, A, this is the first time that's being raised, but B, I think it's the Privy Council's decision in Vizcaya Partners versus Pictard, which is at page 1061 of the electronic bundle, tab 63. I can take you to this case. That must be the wrong. Sorry, 1628 is the page, and really it's paragraphs 73 and 74. The argument over, I think, was whether there had been a submission in this case to New York by virtue of a clause, jurisdiction clause in the contract that they were looking at. But what the court held was, look, in an insolvency, the claim isn't arising by contract, it's arising by the statute. And if you go to paragraphs 73 to start at page 1649, it says, paragraph 73, the trustee would, in any event, have other formidable difficulties. The first is that if a jurisdiction agreement is to be implied as a matter of fact or law, prima facie, it would not apply to these proceedings. In AW Geneva SA versus North American Steamships, and I think we have that case is in the bundle if you wish to refer to it, a swap agreement provided that pursuant to an ISDA master agreement, the agreement was governed by English law and subject to exclusive jurisdiction of the English courts. The trustee of one of the parties brought a statutory avoidance proceedings in Canada. The Court of Appeal refused to grant an anti-suit injunction because the choice of law and choice of jurisdiction agreement did not apply to insolvency proceedings. They were part of the proceedings in Canada did not relate to a dispute under a contract. They were part of the insolvency proceedings.
Yes. So your point is that the clause in the subscription agreement is concerned with issues arising out of that agreement and not insolvency proceedings.
Yeah, and secondly, my Lord, we're a creditor now. We're not a shareholder. From the moment our notice of redemption was accepted and we were paid out.
Yes.
So we're not governed by contract as a shareholder.
Yes.
That's the point there. The other thing that was raised,
I think perhaps I had got it into my head that you had until 1 o'clock, but I was mistaken.
you were mistaken.
And you're past your time, so I won't encourage you to go on any further, Mr. Sims, for the moment.
Okay. Perhaps one last point, which, well, I can deal with it in reply. It's a point raised by the other side. So unless I can be of any further assistance.
Yes, that's my feeling. Yes. And does your junior have anything to add? Thank you very much. Ms. Walton.
My lords, I hope you've managed to read some of my case. I'm not going to repeat it, except in one or two places. The big question is, can a liquidator of an IBC Act company effectively make a claim against a foreign investor stroke creditor of the company? My overarching submission is that the answer lies in the title of the statute, the International Business Companies Act. If a liquidator is unable to claim against foreign investors and creditors, he will be unable to carry out his duties under the Act, in particular in relation to fraudulent preference claims, but also some of the other winding up provisions of the Act, and the Act will be rendered futile. In my submission, in order to obtain leave to serve out, the liquidator must show, firstly, that the statutory provision in question has extraterritorial grasp. Secondly, that there is a route to access the court. Thirdly, to show a good cause of action on the merits. And fourthly, to show that the court's discretion should be exercised in favour of service out. And my submission that follows the approach that the Court of Appeal took in both Paramount and in Oxerin. So my four main submissions are, first of all, I'll call it the legislative grasp point. A foreign creditor who's been fraudulently preferred is clearly within the legislative grasp of the IBC and Section 160. The root point, my second point, that the rules of the Supreme Court, Order 11, was the correct route for the liquidator to access the court to obtain permission to serve the fraudulent preference claim application. Thirdly, the good cause of action point, the evidence satisfies the tests on the merits. There is a good cause of action or serious issue that ZCM were fraudulently preferred by AWH. And fourthly, the discretion was correctly exercised. ZCM can't reap the benefits of an investment in a Bahamian IBC without also being subject to its laws. That's my cake and eat it point. And there was sufficient connection between ZCM and the Bahamas. To come to my legislative grasp point first, I have two propositions under this point. Firstly, the AWH is a typical example of an International Business Company Act company. And secondly, as a matter of interpretation, Section 160 of the IBC does indeed have extraterritorial grasp. My Lords, before I go to the IBC Act, I want to refer the Court to the petition, and that's in the Appeal Documents bundle, tab 1. And it's E-page, if I can call them that, 6. I hope you can read it. There is a better copy, actually, at E-page 107, sorry, 105. Firstly, note that the petition is actually, the petitioners are companies incorporated under the laws of the Cayman Islands, so the petitioners were foreign creditors. Paragraph 2, you'll see that the company actually started off as AFAM Asian Warrants Hedge Fund. It basically dealt in hedge funds abroad in the eastern part of the world. The company's registered office was in the Bahamas with Fortis. Paragraph 3, the company's a mutual fund. Its investment manager was a company incorporated under the laws of Hong Kong. Further down in that paragraph, that investment manager was replaced by Glanville Asset Management, Inc., which was a Panamanian company, and Glanville European Management Limited, which was a UK company. Mr. Philip Oxon, at the bottom of paragraph 3, as an officer and director of GAM and also a director of AWH, and he lived in Switzerland. Paragraph 4, the custodian, sorry, paragraph 5, the custodian is an American company of the investment, State Street Bank. And Lord, this shows the very international nature of this company. Whilst you're here at the petition, I ask you to note paragraph 8 of the petition, which goes some way to explain the collapse of this company. The Articles of Association of the company were amended and restated without reference or notice to the shareholders, and included in the amended Articles of Association was a clause that gave the directors the company to power to amend the articles or any material contracts of the company without consulting the shareholders. The former investment manager had a cold shoulder order issued against it, and that started the collapse of this company. The story is there in the petition. I also ask you to note paragraph 11. By letters dated the 15th of July 2002, the petitioners, that's the two Cayman Island petitioners, creditors, gave notice that they wished to redeem their shares in the company. Then by letters dated the 10th of September, Fortis informed the petitioners that only 16.39% of their total redemption proceeds would be paid, and such payment was made. I draw that to your attention because in the meantime, after that redemption request had been made, ZCM received the full amount of their shares, their redemption amount, which is the liquidator's fraudulent preference claim. And while we're in this bundle, my lords, could I ask you to go to tab 2, page 16, 15 actually. This was a hearing in front of the Honourable Justice John Lyons to set aside the stay of the petition. And can you note that the court there heard counsel for the two the petitioning creditors, but also they heard Zurich Capital Markets Asset Holding Company as contributors and creditors of the company as part of the investment group. So ZCM had already actually participated in the petition. And it was ZCM, not Amex, American Express, and they described themselves there as contributors and creditors of the company. So they had appeared in the Bahamas. And you do wonder why we're here, actually. In fact, they had served a notice in January 2003 to appear at the hearing of the petition to oppose it. For some reason, that's been left out of the bundle.
Sorry, what's your point about that? I mean, you're saying they submitted to jurisdiction all those years ago.
They've effectively submitted to the jurisdiction of the Bahamian court already.
Yeah. Where does that...
By taking part in the petition.
But you're not saying that makes this whole appeal...
No, because I think that the reason that we're really here is that it's felt by both parties, and it was felt by the Court of Appeal, that this was an area of law that needed sorting out in the Bahamas. How to serve out of the jurisdiction.
Well, that may be, but, but nevertheless, if the appellant submitted to the jurisdiction in 2004, then why, yes, I mean, apart from the sort of public interest in clarifying the law.
This very recently, when I got the bundle. It was last week.
Lord, it's not accepted. Firstly, you'll notice the names of the companies are different. Secondly, when we get to the law, of course, a submission to a liquidation can only be done by a proof of claim, et cetera. So no explanation of those facts before the court. This is the first time this is being raised. So,
Is it not the same company?
no, not by name.
The one we have the name of, I'm looking at the April 2004
Appellant
order.
is ZCM Asset Holdings Company, Bermuda Limited.
Yes.
This company appears to be Zurich, spelt out Capital Assets Holding Company Limited. So there's no evidence to say what it is or whether it's the same company. In any event, as I say, for legal reasons, it doesn't make a difference. And also, this is the first time that this argument is being raised. And we don't have the factual background before this.
Again, whilst we're in this bundle, could we go to tab 16?
Sorry, just so you know it, my lords. As I said before, all the shares have been redeemed. The evidence is all the shares have been redeemed in July of 2002. So the applicant wouldn't have been in its capacity, presumably, of FBO American Express, even if this was it, they weren't there in that capacity. So they had redeemed all the shares.
This is the affidavit of Alan Bates. It was in answer to another affidavit, really to show that the ZCM is a shareholder, was a shareholder of the company, by exhibiting the shareholder register. And if you look at that shareholder register...
Can I have a page number?
I'm just trying to find it. It's 271.
Thank you.
And the following pages, really 272.
Is this the,
In the hard bundle, it's 271. Tab 16. Page 272 or 271 has it's the shareholders' register.
Yep.
And if you look down that, you will see that all the shareholders are foreign registered. The last column says the country, and you'll see ZCM Asset Holding Company Bermuda Limited there is described as an Irish company, and then a bit further down it's described as a US company. But my point here is that all of the shareholders are not Bahamians. So now I want to turn to the IBC Act itself, the whole thing, which is in Bundle 2 at page 35, and it's page 1083.
would this perhaps be a convenient point at which to adjourn?
I'm sorry?
Would this be a convenient point at which to adjourn?
Yes, it would, since I can't find the place.
I thought it might be. Very well.
Grateful.